I want to start by distinguishing myself from the other panelists. Obviously, we're all highly competent and very personable, but Marissa and Kevin and Bruce are all attorneys. I am not. I like to remind people when I'm in a public forum, so this button, if you can't see it in the back, says not a lawyer. What I do and what ACO does is different. We're able to share from our experience. We can give our personal opinions as long as we make clear to people we're talking to, such as you, that we are not giving legal advice. We may occasionally recommend that you get legal advice to deal with your personal issue. It is not something we do ourselves. Early on in my work, I came to realize that there are many organizations representing renters. There were none representing owners. There are terrific organizations and institutions to help deal with condo and co-op issues. CNYC, the Federation, Habitat Magazine, the Cooperator. I read these periodicals, I go to the seminars and exhibitions. I've been a dues-paying member of some of these groups. All of them focus on buildings or associations or corporations, and their members are boards. None of them dealt with individual owner and shareholder issues, and that's why ACO was formed. Our mission tonight is threefold. We'd like you each to leave a bit more knowledgeable than when you arrived. We'd like you each to leave a bit less frustrated, maybe with some hope that your personal issues can be resolved. And we'd like everyone to consider joining ACO if you haven't already. Browse our website. There's a lot of content there that you might find useful. And if you like what we do, membership costs $1 per person per year. If you like what we do, friend us on Facebook and spread the word. I want to emphasize that in speaking for owners, we are most definitely not anti-board. There's a profound distinction, and I remind you that most ACO directors are currently or have been board members and officers ourselves. Personally, I know many owners that are happy. I know many board members that are excellent fiduciaries, and I know lots of buildings that operate without issues of consequence. When we can say that about every building and every board and every owner, we're going to close our doors because our work will be complete. We're not there yet. Collecting stories is a very large part of what we do, and tonight, instead of reciting legislation and initiatives that we're working on, I'm going to share a half dozen stories that we've heard in the last couple of months. Partly because they're much more interesting, and partly because I think they illustrate very well why we do what we do. Case one is attorney fees. Jean has lived in a medium-sized co-op for over 20 years and has never been in arrears. She came home one day to find her kitchen ceiling on her kitchen floor. She called the agent immediately and was told that the humidity had been very high and that was the cause of the collapse. The building disclaimed all liability for the problem. In a smart move, Jean hired an engineer to ascertain the cause of the collapse before any repair work was done. In a lucky move, she hired a professional cleaning company to deal with the mess. And when they walked in, they said, "It's funny, we were just here 2 weeks ago cleaning up after the pipe burst upstairs." So much for humidity. At this point, Jean had excellent evidence, but the building wouldn't budge. So she filed in small claims court. And through persistence and dedication and a lot of hard work, she won an award for $2,000 to handle her repair costs and the cost of the engineer's report. It was hard work, it was worth it, she was relieved, but it didn't last. A couple months after her favorable award, she found a line item on her maintenance bill for $4,000 in legal fees. Somehow her co-op board had decided, had rationalized that it was okay to bill her for their failed defense. She protested, of course, got nowhere, paid every cent except for the legal fees, and the next month it was the legal fees plus a late charge. Obviously, this could continue indefinitely, at least until the point where she's evicted for non-payment. Case two, also attorney fees. Mary and John bought an apartment upstairs from a board member with a huge terrace. After they moved in, the board member installed a permanent barbecue complete with a natural gas pipeline. When the wind is right, their living room fills with smoke. First place they looked was their rules and regulations that they got as part of their condo package. The rules and regulations say, quote, no cooking on terraces. Mary and John found this unambiguous, and they started asking questions of everyone they could find, but they got no answers. The annual meeting rolled around, and they asked there in a public forum. The condo board handed it off to building council, who was present, and building council said, please put this in writing, and I'll deal with it. They did that the next day. They heard nothing for 4 months. Then they saw a line on their monthly bill for $200 in legal fees. They couldn't imagine what it was, inquired, and sure enough, they were charged for the attorney's time writing a letter of opinion to the board on the question they asked at the annual meeting. There was no indication at the meeting or anywhere else that an owner could conceivably be billed for asking a question. To top it off, they never saw the answer to the question. The opinion letter went to the board. They got the bill. To this day, they don't know what it said. They paid their entire monthly bill except for the $200. Next month, $200 plus a late fee. Sounds familiar. Case 3, the audit. George lives in a modern high-rise condo, which is starting to show its age. So he was very pleased to hear that the board had hired a first-rate engineering firm to study the building top to bottom. He knew that this would shine a light on upcoming expenditures and allow them to put together a good fiscal plan. That's why George was puzzled when the next auditor statement contained the routine disclaimer, which you've probably all seen. The board has decided not to conduct a study as recommended by AICPA to determine remaining useful lives of equipment and estimated costs of repair and replacement. This is exactly what CNYC recommends that boards say. They said, don't do a study. But in this case, the study was done. So George was puzzled, and he managed to obtain a copy of the study. He got the engineer's report, and he read from it the objective seemed clear, quote, perform a roof-to-cellar physical condition survey that outlines all deficiencies and includes budget projections on the cost of corrective work. Nothing ambiguous there. The annual meeting came around. George, before the meeting, asked the auditor about the engineer's report. He was shocked when the auditor had not seen the report. George offered him a copy, and the auditor declined, saying, the board will tell me what I need to know. When the meeting got underway, he asked the question again, and the auditor said that the engineer's report, which he had not ever seen, quote, did not rise to the level of the AICPA standard. All the professionals present, the CPA, the board's attorney, the managing agent, then piled on together with the board members, and they said it wasn't that kind of report. Afterwards, George talked to his fellow owners, and they were all convinced that what the professionals were saying was true. How could they all lie? Why does this matter? It matters because the board wrote to the owners, and they summarized the engineering study, saying that $800,000 was needed to be spent over the next 5 years. In fact, the actual report identified $5 million in required capital projects, and $2 million of that total was marked urgent by the engineer. That information was withheld from all the condo owners. George is presently debating whether to move before the big assessments hit, or worse, before someone gets injured by infrastructure that is unattended. Case 4, dissidents. Steve lives in a large co-op in Queens. He called with a fairly common complaint about being disenfranchised. One of his concerns was that the board was about to do a mortgage refinance that he thought could bankrupt the building. So far, routine. 3 things were different about this case. A, Steve was on the finance committee, and he was joined in his concern by several former board members and officers. B, they organized a petition for a special meeting and an election, and not only did they reach the 25% threshold, which is common to require that a special meeting and election be held, they got more than 50% of the outstanding shares to sign on, saying, let's have this special meeting, let's recall the board and have a new election. C, they managed to get one of the best, most highly respected attorneys in all of New York to handle their case pro bono. So it sounded to me like a slam dunk. You have excellent representation. You've got more than half the outstanding shares saying, let's do this. They failed. The board is still in power, and they said, now we can move on and do what we need to do. Last story is simple and unbelievable. It's about a certificate. I got a call last week from a chief of staff in a city council member's office. And a constituent learned that his mortgage bank had lost his certificate of shares. He wanted to sell his apartment. It doesn't happen without the share certificate. I hear this a lot. Ask any broker. It happens often. So I thought the next thing would be a complaint about the cost of the replacement certificate or the delay. How long is this going to take? I was not prepared for what I heard. The board will not issue a replacement certificate. It was new to me. It was new to everyone at ACO. We called a couple of attorneys and said, have you ever heard of something like this? No. Is it possible for the board to refuse? Well, the documents usually say the board may replace a certificate of shares, but it doesn't say they must do it. So our final question was this to the attorneys. Is there any easy way, without a shareholder hiring an attorney and going to court, to force the board to comply with what everybody knows the board has to do? And the answer was no. Those are my stories. Our research that ACO has done indicates that problems like these 6 examples can all be settled with less litigation, less expense, less delay, and less acrimony than is currently happening. Through educational activities like this forum and through specific legislation, we're working toward those goals and we're advocating for all owners and shareholders. We hope that you'll join us.